Mistake. You may have heard the saying, cave ademptor, let the buyer beware. The onus under the law of contract is on the parties to ensure that they are entering into a bargain which is satisfactory to them. Although there are circumstances in which the law will set aside a contract based on mistake, or give parties particular rights in respect of certain contracts, especially contracts entered into at a distance, the general rule is that the courts will not intervene to unwind a contract simply because one party feels that they got a bad bargain, or that they paid insufficient attention to what it was that they were doing. In this podcast, I will first discuss the law of common mistake, where both parties to a contract are mistaken. Then I will move on to talk about the law of unilateral mistake, where mistaken belief is held by only one of the parties, and I will conclude with a look at mistaken identity and documentary mistakes. The law of common mistake comes under three headings: res extincta, res sua, and mistakes as to quality. Under the principle of res extincta, if the substance of the contract is something which, at the point of contract, no longer exists or never existed, and the parties do not know this, the contract will be void. Take, for example, the case of Scott and Coulson, in which Scott tried to sell Coulson a life insurance policy for a third party, C. However, at the point at which the policy was sold, C was, unfortunately, already dead. The parties did not know this. As such, the contract for the life insurance policy was held to be void under the principle of res extincta. Res sua is the principle that, where, unbeknownst to the parties, a buyer purports to buy something which he already owns, the contract will be void. The third category is mistake as to quality. Case law has produced two lines of thinking when it comes to this type of mistake. This is the situation in which both parties are mistaken about the nature of the item or service being sold. For example, if both parties think that a painting is a rare and valuable old master, and enter into a contract which is priced accordingly, but subsequently discover that the painting is in fact a copy. The first line of thinking is that a mutual or common mistake as to quality is never a ground to overturn a contract. The second is that if the mistake is sufficiently fundamental, it can be a ground for overturning a contract. It seems that the courts currently are more inclined to this second view, and that where a mistake renders performance of the contract impossible, it can overturn an agreement. There are three cases that I suggest you read. The starting point is Bell and Lever Brothers from 1932, in which the parties entered into an agreement to pay compensation to Bell for the termination of his employment. Because of certain dealings in Bell's employment history, the defendants would have had the ability to terminate Bell's contract without paying consideration, although at the time of the agreement neither party appreciated this. The House of Lords held that the mistake did not overturn the contract, although exactly why they found this is not wholly clear, as both of the lines of thinking above were advanced. The second case, which starts to establish the modern-day approach, is that of Associated Japanese Bank and Credit du Nord from 1989. This case dealt with what was purportedly the sale and leaseback of some textile machines, seemingly part of a company's restructuring. It turned out that the agreement was essentially a sham, and that the equipment purportedly at the centre of the refinancing, the textile machines, did not in fact exist. Should the non-existence of the machinery, known by the third party but not by the two finance companies involved in this case, be treated as a mistake of quality, and if so, should the contract be overturned? The Court of Appeal decided the case not on the basis of mistake, but on the basis of a term of a contract, implied if not express, that the machines existed. However, had there not been such a term, Justice Steyn commented, arguably obiter, that the law of common mistake would be engaged here, since the contract was of an essentially different nature without the existence of the machines. The final case is that of Great Peace, a 2003 case, in which a company contracted with a ship's operator for the use of the ship Great Peace to assist in a salvage operation. There was a misunderstanding as to the location of the ship, and the defendants sought to terminate the contract on finding that the ship was actually several hundred miles further away from where they had thought it was. The Court of Appeal found for the claimants, upholding the contract on the basis that the fundamental contract was for ship hire, and that the mistaken understanding of the location of the ship, a few days of travel, did not render the contract essentially different. This was particularly true as the defendants did not cancel the contract until after they had found a better placed ship, being seemingly willing to put up with the extra distance and delay if they could not find a better alternative. Lord Phillips established 5 principles which must be present for common mistake as to quality to be made out, and these are at paragraph 76 of the judgment. The 5 principles are these. Principle 1 is that there must be a common assumption as to the existence of a state of affairs. 2, there must be no warranty by either party that that state of affairs exists. 3, the non-existence of the state of affairs must not be attributable to the fault of either party. 4, the non-existence of the state of affairs must render performance of the contract impossible. And 5, the state of affairs may be the existence, or a vital attribute, of the consideration to be provided, or circumstances which must subsist if performance of the contractual adventure is to be possible. Where all 5 of these circumstances exist, a court is likely to find that a common mistake is sufficient to overturn the contract. I discuss in a later podcast the law of frustration, which is an event which makes a contract impossible to perform, and which has the effect of terminating a contract from that point onwards. The key difference between mistake and frustration is that mistake happens at the point at which the contract is made, what you might term initial impossibility, while frustration occurs when the impossible event happens after the contract is made, what you might think of as subsequent impossibility. Moving on from common mistake to unilateral mistake. The circumstances in which a court will find that a mistake by just one of the parties is sufficient to overturn a contract is very narrow, and is limited to the situation in which there is a mistake as to the terms of the contract, rather than the subject matter or the quality of the subject matter. The case of Smith and Hughes explains the difference in a case involving the sale of some oats, in which the oats turned out not to be the oats that the buyer wanted. And the court held that if the seller had known that the buyer mistakenly thought that the seller had warranted that the oats were the right type of oats, there would be a mistake as to the terms of the contract. Whereas if the seller had merely known that the buyer was mistaken as to the type of oats, that was a mistake as to quality. Any mistake in such a case would be unilateral, as the seller knew of the mistake, but the buyer did not know that they were mistaken. Similarly, mistaken identity, again, is very limited in the circumstances. The court will only find that mistake as to identity of one of the parties to a contract is sufficient grounds to void a contract, where the mistake is about a person's identity rather than an attribute of the person, and identity must be crucial to the contract. This appears to be a very high threshold, seemingly limited to the situation in one party intended to contract with a particular firm or individual to the exclusion of others. See the 1871 case of Bolton and Jones. Contracts concluded at a distance are more likely to receive sympathetic treatment than face-to-face contracts, although even then the case law is not entirely consistent. See the cases of Cundy and Lindsay, Lewis and Averay, and Ingram and Little. The final category of mistake that I will talk to you about is that of documentary mistake, and there are 2 specific remedies which deal with mistakes and written agreements. The first is a claim of non est factum, that the document in question is not mine, and the second is the remedy of rectification. The plea of non est factum is an old remedy designed to assist those who enter into a documentary agreement in reliance on another party due to a disability. The claim is that the document signed was not the document which the signer intended to sign, and the classic non est factum situation would be that in which someone who was blind or illiterate signs a document, having been assured by a third party that it has the effect that the signer intends. However, the third party has not been truthful, and in fact the signer has signed something completely different. Their claim is that the document they signed was not the bargain which they thought they had agreed. The scope of the plea is very narrow. The difference between what the signer thinks they are signing and what they are actually signing must be fundamental, going to the very root of the contract. It's also a requirement that the signer must not have been negligent or careless in signing the document. See the case of Saunders and the Anglia Building Society. Someone seeking to claim non est factum will have to overcome a high burden of proof to prove that they were not careless, particularly someone who is literate and not suffering from a lack of capacity. Simply not reading a contract and subsequently finding out that it does something other than that which you intended is not a basis for a plea of non est factum, and is unlikely to be seen favourably by the courts. See the case of Lestrange and Graucob. The second remedy is that of rectification, and it deals with a situation in which the parties entering a verbal agreement document it incorrectly in writing by mistake. There are 4 requirements to make out the basis of rectification. The first is that the parties must have reached an agreement or have a continuing common extension, the case of Jocelyn and Nissen. Second, the written document must not correctly record what the parties have agreed when taken objectively, Craddock Brothers and Hunt. The third is that the written document must fail to express the common intentions of the parties, Rivergate Properties and Paul. And finally, rectification must be equitable. Take a look at the cases and understand how each of those points comes to rise. The last aspect I want to talk about is distance contracts, and I will discuss these in detail in a later podcast. But while they do not alter the law of mistake, the additional rights which are afforded in certain cases under distance contracts may mean that the law of mistake is less relevant. If a party has a contractual right to end a contract within a certain period of time after they enter into it, provided they must spot the mistake in good enough time, or even if they just simply change their mind, they may be able to exit the agreement. So to summarise, the law of mistake has 4 bases: common mistake, unilateral mistake, mistaken identity, and documentary mistakes. However, as a general principle, it is very narrow, and courts are generally shy to simply unwind a bargain because one of the parties thinks that they made a mistake. To argue for common mistake, you will need to fit it, to argue for any mistake, you will need to fit it clearly within one of the established categories of law and make a case that the court should overturn the contract.